Thank you so much, Advocate Arons. Mr. Chetty, good morning. Good morning to you. Your microphone was not on. If it is green, it means it's not on. It must be red, so that whatever you say goes into the records. Good morning to you.
Good morning, Chairperson.
Yeah, thank you so much. We are going to administer oath on you, so that whatever information or evidence that you give us is recorded under oath. But before we do that, let me say the following to you, that you have been invited here before this ad hoc committee which investigates the allegations that were made by the KwaZulu-Natal Provincial Commissioner, General Mkhwanazi, with the belief that the information that you are going to give us shall help the committee in its oversight and investigative work. The allegations include, amongst others, number one, the alleged unlawful disbandment of the Political Killings Task Team, otherwise known as the PKTT or the NPKTT. Number two, alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS. And number three, alleged corrupt relationship between the SAPS senior leadership and members of the public. And lastly, number four, alleged political interference in the work of the SAPS. In extending the invitation to you, the chairperson of the ad hoc committee has indicated to you that you may provide such information to the committee if you so wish, under oath, in terms of the powers, privileges, immunities of Parliament and Provincial Legislatures Act of 2004. Mr. Chetty, please be informed that by law you are required to answer any question fully and satisfactorily. Of course, questions that are lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the documents that you give us could incriminate you or expose you to criminal or civil proceedings or even damages. Mr. Chetty, you are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it that is false or misleading commits an offense and is liable to a fine or a term of imprisonment not exceeding a period of 2 years. You are required to take an oath or affirm that the evidence you shall give shall be truthful. Which one do you elect, oath or affirmation? You have elected to take an oath. May you please follow me as I dictate to you. May you please say aye and state your names in full.
Krishna Chetty. I put it off.
Yeah. Let's repeat that, Mr. Chetty.
I, Krishna Chetty,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
And so help me God.
Thank you so much. I'm handing over to you and the senior counsel to start with the presentation of evidence. Can I check, senior counsel, how many hours do you need to conclude the presentation of evidence?
Chair, always difficult to predict, but I wouldn't expect us to be longer than 2 hours, if that long. As I said, you and the honourable members would have gone through this affidavit. It's lengthy, but it's full of technical, legal.
No, it's fine. If you need 2 hours, let me exercise my benevolence and say that you run until 13 hours. By that time, Mr. Chetty and senior counsel, you must be done with the presentation of evidence.
Thank you, Chair.
Do everything within your abilities to ensure that by that time you are done. Thank you.
Thank you. Thank you.
Let me wish you good luck. Thank you.
Mr. Chetty, you reference a number of cases in your affidavit. There is the Silverton case, which is case number 335/2/20, and then there's also a number of other cases.
Sorry, I don't understand.
Then there's also a number of other cases. Silverton case numbers and Brooklyn case numbers. Now, in our discussion and in my understanding, you had initially been an accused with some 70 other accused, which is some 40 odd natural persons and 30 odd juristic entities, companies, CCs, in case 335. We can call it 335. That case, which is referenced in paragraph 1.1, honourable members, that case was in March 2021. Is 2021? 2020.
2020.
2020.
4th of June, 2020.
4th of June 2020.
Yes, we were arrested.
The case was struck off the roll.
No, it was struck off the roll on the 25th of March, 2021.
Yes, that's the one I'm referring to. March 2021. The case was struck off the roll in terms of section 3423, capital letter C, by the magistrate. Is that correct?
You're correct, counsel.
And that's what we can call the big case, right?
Yes.
Subsequent to that, there have been several. You were arrested and charged in several other cases, which, as it were, mutates from this big 335 case. Is that right?
Yes, counsel.
And those are the cases that we see referenced there: Silverton 143, 145, 142, and Brooklyn, and 147. So those cases, they are taken from the big 335 case. Is that correct?
Yes, counsel.
And your case is that in itself constitutes an abuse, because 335, in terms of 335, I think we know now from another experience with another witness, when we deal with 342, striking off, that it can be enrolled, but it can only be done if a certificate is issued by, these days, the National Director of Public Prosecutions. And that was not done. Is that right?
Yes, counsel.
But I think in our discussion, subsequently, you say that 335 has been reinstated.
Yes, counsel.
Okay. So we also know from our consultation that you have brought an application to have these cases set aside on the basis, amongst other things, of an abuse of the process and unlawful interference in these matters. And that case is still pending in the High Court. Is that right?
Yes, counsel. We're waiting for a judge to be allocated to the matter.
Yeah. So, and you appreciate and understand. In fact, you to your credit, you pointed out to me that you are not here to debate the merits of these charges against you. The charges in case 335 relate to theft, corruption, money laundering, and quite a number of serious charges. Is that right?
100%, counsel.
You're not. You're obviously defending these charges, but you're not here to debate the merits of those.
No, no, I'm not.
Your complaint before the committee is you link it to the terms of reference of this honourable committee, and that is interference, unlawful conduct, unethical conduct on the part of the police, and you in particular point fingers at officers Beluchan, Shabalala, Perumal. Are they? Shabalala is a prosecutor, is that right?
Yes, he's a prosecutor in all my cases.
In all your cases?
Yes.
And Perumal and Belushan are with IDAC?
Yes, with IDAC now, yes.
And Low, the other person?
Paul Lowe is an advocate that is at IDAC.
At IDAC.
Under correction, is Shabalala's senior.
Okay. And those, you say they're the main actors in the narrative that is in your affidavit?
Yes.
But we also know now, in fact, perhaps tell us about the call you received yesterday from IPID.
Okay, counsel. I opened a case 12/7/2022 Silverton case in 2022 after I realized that charges were taken off a case that was struck off the roll, 335, and it was duplicated in case 143, 144, 145, all Silverton cases. I then opened the criminal case. It was then taken to Gauteng province. Everything is in my affidavit here, so let me just talk about that case 12/7 as you're asking me about the call. I received the call day before yesterday from Mr. Beloy at IPID, because 12/7/2022 is at IPID's office now. And Mr. Beloy told me that the advocate from the DPP's office, North Gauteng, called him and asked him to come and collect the docket and obtain warning statements from these three individuals: Dylan Perumal, Sunil Beluchan, Richard Shabalala. And I then told Mr. Beloy that I will be coming here today, and he must please tell me, like last night, if he called him so I can put it on record here, because on my affidavit, it shows exactly what has happened to this docket since I opened it in 2022 to where it is now. So Mr. Baloy did tell me that he contacted Sunil Baluchan and informed him that he needs to obtain a warning statement, and he couldn't get hold of Dylan Perumal and Richard Tyler Shabalala, reason being that they on leave. So that's where it stands now. But in my affidavit, it stipulates exactly from the time I opened the case, it went up to the DNC's office, up to General Libia's office at the Hawks, and it shows the abuse of power everything is in my affidavit. So on the call that I received yesterday, that's it. It's with Mr. Baloy now. The docker is with him.
So that case is also currently pending and being dealt with by IPID.
Yes, and just to bring it up, explain what it is, that case is what I'm here for, on the duplication of charges from the case struck of the roll to the baby cases that was opened. That is based, that is my complaint, that is 12 of 7, 2022.
Yes.
Yes.
Now, what would you want this honourable committee to do or to recommend some remedial action in view of the fact that your complaint against Baluchan, Perumal, Shabalala and Low, those cases are being dealt with by IPID. You've also complained to some very senior SAPS officers about their conduct, that case is pending, and your High Court application to have these cases set aside, that case is also pending before the High Court.
Counsel, I would appreciate the committee to see or understand the exact abuse of power this IDOC officials, the courts, especially Palm Ridge Magistrates Court, Pretoria Magistrates Court, Pretoria High Court, on how these individuals bring cases on the roll as they please and not following the court rules, the uniform court rules of the court. Because I did a lot of background checking as we go through my affidavit. The committee chairperson will see what my allegations are, because I have all the next years of court books. We're appearing in court, but we're not registered on the court books. I have transcripts and so forth. So basically, it is on the abuse of power of these guys. And when I do complain about them, I'm getting arrested, or they're retaliating on me by using state machinery. And I have proof of all of that.
And your status currently is that of an accused in all of these cases, and you sorry. Sorry, thank you.
Thank you, Chair. I'm sorry to interrupt Mr. Orrington and Mr. Chetty. Chair, I've gone through this affidavit, and I'm very concerned that, well, I'm concerned about the contents thereof, and I'm concerned about why Mr. Chetty is here today. But I'm more concerned about the fact that he's not here with any representation, which is also a concern to me. Advocate Orrington is not his legal representative, he's the evidence leader. So Mr. Chetty is not his client, and he doesn't have to advise him in his best interests. But Mr. Chetty is the accused in a number of very serious matters that are currently on the roll or to be placed on the roll. They're currently in court. And I don't know if his legal representatives in that matter know that he's here. And I don't know if they helped him draft this affidavit. But my major concern is that we operate on a principle of innocence until proven guilty in this country. But he stands an excellent chance today of doing himself a lot of damage in those matters that are on a criminal roll. And that's really something serious that he should think about and we should think about. Because he's just said he's here for 2 matters. Well, that's not really why he's here. Now that he's here, we can ask him about whatever we want. And he's obliged to answer. He may well find himself in a position where he has to incriminate himself. He's not represented. He's got no one to advise him. It's not our job to advise him. So I'm concerned about what we're busy doing here today is, for me, not quite right. But I'm also concerned about his position in terms of his constitutional rights and his right not to incriminate himself. He's not a lawyer. He's a businessman. As he says, not doing business at the moment. So those are my concerns, Chair, and for me they're serious concerns. Thank you.
Let's see. What is your response?
Honourable Chair, as I indicated in some introductory remarks initially, it was Mr. Chetty's father who had lodged a complaint, but it was about the conduct of a curator in a matter. I'm not sure whether it's in relation to one of these criminal matters, but I know they're also facing some charges which the investigating officers say emanate from tax fraud. But subsequently, only last week or the week before, a substantial affidavit was sent to Mr. Romano, which was then passed on to us. And we were required to consult with a witness initially. Advocate Mkhwanazi was going to lead Mr. Chetty's evidence, but you'll recall that on the day, I think it was last week, we either couldn't accommodate him, and he was he's come back. The concerns raised by Honourable Breitenbach are shared by us, and that's why I indicated also at the outset that I will try and make sense of what's in this voluminous affidavit, and I'd also asked what, if anything, this Honourable Committee can do other than what I did, which is to read the affidavit and listen to Mr. Chetty very sympathetically. According to his narrative, he seems to have been badly treated. But again, it's just one side, or one side of a story, and I'm not sure that there's anything we can do about this other than to note his claims, and I suppose significantly the names of Baluchan and Perumal and some of these officers, their names have cropped up in some other matters from other witnesses. So that might indicate some kind of pattern. But the fact that IPID is now investigating the case that he has brought against them, the fact that there is a High Court matter that's pending and awaiting the allocation of a judge, where in the correct forum, a judge will, having heard argument from all sides, from both sides, will make a determination whether or not these cases should be dismissed, and the prosecutions not proceed, which I'm not even sure that a judge can do, given that these are all matters that's pending before different courts. So all that I'm saying, it wasn't for us, Honourable Chair, as evidence leaders, to make a call and say, no, we don't think you need to hear this witness or listen to the witness. It's going to be a waste of time. We were asked to consult with him, to interview him, and we are here now today other than in summary to say, I think the concerns raised by Honourable Breitenbach are valid concerns, and that perhaps the better thing, or the better course to take, is to note what's in his affidavit when the committee comes to its deliberations, and to take serious note of some of these allegations, which some of them are quite hair-raising. These Silverton and Brooklyn cases, they arise from this big 335I case, as he called them, baby cases, and it's been done selectively. But again, it's either for the trial court to make that determination. I don't think we equipped. Maybe Honourable Breitenbach is in a former job, but we're not equipped to, or maybe Mr. Novalo as a practitioner. Thank you, Chair. I'm sorry if I'm not being particularly helpful.
Yeah. No, let's do this now. Okay. Can I hear you?
Thank you, Chair. Yes, Chair, in the defense of senior counsel, he is not known for being a criminal lawyer. His expertise lies elsewhere. I honestly submit, it's my view, that we're about to seriously prejudice Mr. Chetty. Whether he realizes it or not is not really relevant. We're about to do serious damage to whatever case he may have. And I would urge him to not proceed with this. We can take note of this affidavit. There is stuff in here that is concerning, but we can read it. If he opens himself up to questioning, Chair, I foresee serious problems that I'm not entirely sure that I'm comfortable to participate in. Because once he does that, it is our job to question him, and he will really not come out of it well. And it can only prejudice his case. I don't know if his lawyers know that he's here. Certainly if he was my client, he wouldn't be here. And this, the contents of this affidavit, apart from the suggestions that there is foul play with the investigators mentioned, which we already have heard of them and we can take note of and look into, the rest of it is not relevant to this committee's inquiry, in my view. And so we're going to spend a day trawling through, with respect, irrelevant information, not even evidence. And it's the prerogative of a prosecutor. It's not this committee's prerogative. It's not even the court's prerogative. It's the prerogative of a prosecutor to charge people as and how they wish. Of course, every accused is entitled to be charged with everything at the same time, if it happened at the same time and place under similar circumstances. But if not, no. The prosecutor charges in the fashion that they see fit, and nobody can interfere with their discretion. So this committee certainly can't. We can't help him with that complaint. Richard Shabalala is a prosecutor of many years' experience. Paul Lowe is a prosecutor of some 40 years' experience. They certainly know their way around a criminal court. And I'm sure that they're both watching TV right now, waiting for the questions to come. Because please believe me, they will use it against him. And there's nothing to prevent it being done. I really urge us to reconsider what we're busy with here today. Thank you, Chair.
Can I rotate you, honourable members, in here?
Thank you so much, Chair. I think what Honourable Breitenbach is raising, Honourable Vessels would have shared it with me yesterday. And unfortunately, the same concerns that he would have raised yesterday, I didn't get an opportunity to look at the affidavit at that time. But I think it's quite concerning, one, when the evidence later says the actual complainant is not the person who's in front of us. Someone else submitted the complaint, but someone else is appearing before us. Maybe the evidence leader would actually explain to us, boss, if I hear this properly. He actually says, I'm not sure the father submitted, something like that. But as I say, he will actually explain further so that for our understanding of what he's saying. To Chair, I think it's important. It would have been raised by members on our housekeeping committee meetings that between the evidence leaders, the legal unit of Parliament, and the Secretariat, there must be a way of checking unto the nature of the people who apply to appear before this committee. Because it's quite cumbersome now. If every now and then we are to discuss in this setting, in the presence of the person who would want to come and present to us, in front of South Africa, that no, this person was not supposed to be here. The nature of that which is submitting to us was, it would, in our view, Chair, that they would brief you about the nature of that particular submission. So that you come to the committee and advise the committee better, so that the committee takes a decision whether to invite or not to invite that particular witness. But it's becoming a problem. Now, we agree, Chair, the nature of what is said in the affidavit requires a competent court of law. And it's a detriment, it's a legal detriment to Mr. Chetty himself to come and answer here. And you'll recall, Chair, would have said, in a number of witnesses, they are not at liberty to come and tell us what to ask and not what to ask. But when the evidence leader and Mr. Chetty are starting interacting, there is already a condition that I'm not prepared to answer this matter and this matter, then this matter, because it's in court. Now, consistency compels us to say, we have said to General Patlane, we have said to so-and-so, that they are not going to put forward conditions for us to proceed. Now, part of what we pick up from Mr. Chetty's argument in the affidavit is that there are people who are charged by the state to preside or process his cases, which some he accuses of them having been convicted before, both at IDEC and some having been subjected to an internal DC of SAPS. That's a matter, Chair, that I think if we agree on an approach, just to say from IDEC head and SAPS, give us a status of so-and-so, whether or not they got charged, whether or not they were disciplined, whether or not they were convicted, and all those things. But it still matters that Mr. Chetty and his legal representative must raise in a court of law that the nature of how the state has processed my cases has got these irregularities. So I believe, Chair, and we agree from where we're seated, that it's not only a problem of the committee, it's majorly the problem of Mr. Chetty to come and divulge some of the issues in this particular platform that are still subject of a competent court of law. We'll all agree, Chair, that the rules of the National Assembly do not allow us to get into the merits of issues that are still sub judice. So I think, Chair, we must plead with Mr. Chetty, and I'm worried. This may appear as though that we don't want Mr. Chetty to come and talk to us. We'll recall that this is the second time we're discussing his matter, and I'm asking him to go back and come back and all that. It may appear, Chair, that we don't want Mr. Chetty's testimony and all that. But the major concern is that we are to respect the state process and the judicial process. And we are not willing to be part of ruining his case and his presumption of innocence. So it's us pleading with him that he must reconsider, then we'll take it from there. Thank you very much, Chair.
Honorable Nomvalo.
No, thank you, Chair. Chair, I initially when Honorable Breitenbach was raising the matter, I was agreeing with her overwhelmingly. But there's an aspect which I don't agree with. When she wants to project certain people against whom complaints have been laid in this affidavit as a paragon of virtue. He's even citing their experiences and so on. I think that is unfair, and that is being argumentative against the witness before us, because we must be fair to witnesses here. Allow a witness to present, and then when he has presented, you make your arguments. Not to say when a witness has not even opened his mouth, the people that we are complaining about are competent people, they have experience and so on and so forth, as if the witness is hallucinating. That witness is raising these complaints out of frustration. I understand the legal aspects and the legal concerns that Honorable Breitenbach is raising, and I agree with them to say it's going to be prejudicial to the witness when he deals with matters which are before court or which are pending, because even with us, it's going to be difficult to interrogate his testimony, because we will interrogate it with caution. We won't understand to which extent we should go, because we will be trying to save her, and we will be trying to save his right to be innocent before, to be presumed innocent before he's proven guilty. So, but the problem here, Chair, is that our house is not in order. It goes back, and I'm afraid now that witnesses or members of the public largely are going to be on the receiving end of our demise as the committee. But that demise is orchestrated by the legal team. We raised this thing in one of our meetings, Chair, and we asked a question that, what is it that a witness with the evidence leader do during consultation? What are they doing? If here in this committee we deliberate on issues that are supposed to have been dealt with during that consultation, because they have been employed to do exactly that, to say this evidence by its nature does not belong to a committee. Maybe you must submit a written statement, or maybe you must apply to tender this evidence in camera because of its nature. That guidance is supposed to be tendered during that consultative process. But it does not happen. What are they doing? Maybe Advocate Arenzo needs to tell us. What are they doing during consultation? Are they guiding witnesses on legalities or not? Or they just accept, they just say, no, bring everything, we'll just pass it as it is to the ad hoc committee. So I'm very worried, Chair, in as much as I agree with Honorable Breitenbach that now we want to turn away a witness who has come here under an impression that he's going to get an opportunity to explain his side, and who was going to do otherwise if he was properly guided by the evidence leader. So he has been failed by this committee. He has been failed by the evidence leader. And now we want to suffocate him. We want to turn him away. He has compromised all his schedule to come before this committee and argue for his case. When we are here, I understand, members, because we knock off at night here, so we don't get time to read these statements. I've only read it now when I'm here. And I'm getting concerned as I'm here as to what is it that we're expected to do here when a statement from page 1 until the last page talks about cases which are pending before a court of law. So what are we expected to do as members of this committee? So, Chair, I know we're towards the finishing line. we're at the tail end of this process. But our concern remains very high against the evidence leader and his team on how they conduct this work. They are not doing their job during consultation. That is why sometimes we read 180 pages, which is full of irrelevant content. Because during consultation, they must say, no, this one, Advocate Patlane, when he was here, was told by members that, no, these are labor issues. Those are the issues for which he was supposed to get guidance during consultation. To say, no, this one does not fall within the terms of reference. It must not go to the committee. Because he has been employed to do that. So, Chair, unless the witness before us feels strongly that he wants to continue under the guidance that we have given him, or under even after the concerns have been raised about the risk he is imposing himself to, we are saying we're of the view that he must submit rather a submitted statement, I mean a written statement. It's unfair to say he must not submit anything at all because he's complaining about the judiciary here. So when you say the matter is under a competent judiciary, we are already making a judgment that all the complaints he's raising are invalid because the institution that he complains about cannot help him if he feels that it is compromised. How can you complain to the same judge that you are complaining about, to the same magistrate that you are complaining about? So let the client not be helpless. Let's not make him vulnerable and say, no, go away with this statement, we can't help you. If he continues to feel strongly that even after this he can continue, it's fine, he can continue. But as this committee, we have been honest to him to say this is prejudicial, but if he wants to continue, can continue, Chair. Thank you.
Honorable Breitenbach,
Chair.
do you want to speak?
Oh, yeah, Chair, just on one point, I didn't mention Shabalala and Lowe to suggest that they're untouchable. I mentioned them to suggest that they have a lot of experience and they will be watching this because it's an opportunity they wouldn't let go by. Not any other reason did I mention them. Yeah.
Okay. The EFF?
And Chair, I remain deeply uncomfortable with the process.
Okay,
I'm not sure that I want to participate.
sure.
Thank you, Chair. Hey, it's embarrassing. We are an embarrassment to the people that have elected for us to serve here in Parliament, that we can even sit here and while after a witness is even sworn in, that we raise things that should have been resolved a long time ago. I echo my colleague's point of the issue of resources for this committee. I disagree with him that we must put the blame squarely on the evidence leaders. Literally, we have 3 evidence leaders. If you go to that commission, who's pretty much has the same number of witnesses that we are dealing with, they have like a whole team. Our legal team here, our technical team here, they're not here full-time, Chair. And we've been raising this for a very, very, very long time. We even got a letter, or finally the letter was circulated on why we don't even have a forensic investigator. We are an embarrassment to the people who voted for us. Parliament is an embarrassment not to provide adequate resources. And it's got absolutely nothing to do with the fact that we don't have money to be able to serve South Africans with the dignity and the efficiency that we need. It's just embarrassing. And on the merits of what has been raised here, I think it's highly disingenuous to talk about active cases. Pretty much every single person that has come here, senior officials of SAPS, they have active cases. It's not going to be the first time that we've had witnesses, even in committees, where they say, I can't respond to that because it's in court. So to all of a sudden feel uncomfortable participating because someone can be prejudiced is, I don't even know where we're pulling that from. It is something that goes on here. It's even weaponized in this parliament, even in committees, that we shouldn't ask that question because that question is going to jeopardize the case. We hear that it's a long sing-song story. Mr. Chetty has been here. This is his second time. The first time we even sent him away. The fact of the matter, whether this is related directly to our terms of reference or not, it's a bit late. So unfortunately, we're going to have to take his case. There are matters of SAPS that are involved in here, and we are going to hear because we are the People's Parliament, and there's nothing in here that's not related to SAPS. It might not speak directly to the terms of reference, but we are here. We'll hear from Mr. Chetty if he's going to feel like he's compromising his active cases or not. But the story of that prosecutors or whoever's going to be prosecuting his case are listening and is going to be prejudiced, I don't see how that has any relevance here at all. Everybody comes here and they say, I can't answer that because I have an active case. And we allow it. It happens many, many times. So it's up to Mr. Chetty. We are here. It's our fault here. We've let South Africa down. And Mr. Chetty will make the call. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Yeah, I also do feel that it is unfortunate that we are engaged in such a discussion at this point. In fact, midway through the presentation of the chief evidence by Mr. Chetty, it's something that we should actually have dealt with before he came here. Now that he is here, and there are concerns about incriminating himself on some of the issues because most of the matters that he is actually presenting here are before court. I don't see how that is different from General Pahlane's cases, for instance, because he also had a string of issues that before court as I speak, and but I don't see any difference between Mr. Chetty's case and that of General Pahlane. So I feel it's up to the witness before us to decide what he wants to do. If he feels strongly that he needs to continue to ventilate his frustrations before this committee, so be it. Thank you.
Honorable Sols. May you switch over? May you switch off Bangazit?
Thank you, Chair. Look, I have many issues with our legal team, and sometimes with how logistics are handled with evidence or witnesses, etc. But today is not one of those days. I feel that this committee is wrong to, one, blame our legal team and the evidence leader. I disagree. And two, I further disagree that Parliament is an embarrassment. And that's not the message we must send to the country. Indeed, we have limited resources, but we must be honest about what has been done with the resources that we have. We have our evidence leader. We asked for a forensic investigator. You wrote to the Speaker Chair. It's not like it was ignored. The Speaker responded. The Speaker said, we have Advocate Mkhwanazi, who has forensic investigating skills, and she was intentionally appointed because she has that skills. And that replacement was because she possesses that skill. So now, with the limited resources we now have someone here with the investigation skills that we require. So we must not make it look like we are not operating properly here. We are doing the best we can. So I disagree with that position. On the evidence leader and the witness before us, when the witness was here the first time, the evidence leaders was prepared to hear him. It is us as the committee who then asked of Mr. Chetty, because he said he realized that in consultation, the brief consultation they had, all of his attachments was not there. Then, Chair, you ruled that that would be unfair, so you gave it days to say, go get all the attachments to be fair, and then you come back. The evidence leaders follows our mandate. They go and they do that. Now they come back after days. They have the attachments. The evidence leader is ready to lead. We now blame the evidence leader for a mandate that we've given. We don't know Mr. Chetty, but we try to treat everyone in the same way. Lastly, in terms of our terms of reference, what are we meant to do? We are meant to hear anybody that says they can help us to get to the truth around infiltration, political interference, and defeating the ends of justice. We must test that. We did not invite Mr. Chetty. Mr. Chetty offered his information. So let him bring the information and let us test whether it helps us with our responsibility here. So I don't feel that the committee is in a bad position here. Number two, on the issue of Mr. Chetty incriminating himself, we must ask Mr. Chetty, we must give him an opportunity to say, and you must pose the question directly to him. Given the risk that you are potentially going to incriminate yourself by what you are going to present to us, we must ask him, are you willing to take that risk to potentially incriminating yourself by the information? If he says yes, that's consent, what must we do? We will then ask him, we will interrogate him. If he goes to jail because we asked him and he's found guilty, he's found guilty. He must go to jail. We won't visit you, Mr. Chetty. We will be glad that we've contributed to whatever the court will find if you are found guilty. But we can't sit here now and try and protect potential things. We must do our jobs. Just make sure, Chair, that we have his consent on record, that with all the information, he's still willing to testify, and then we go ahead.
Thank you.
Thank you, Chair.
Honorable Vessels.
No, thank you very much, Chair. No, I share the concerns, and I've also, as honourable colleague said, I raised the concerns last night. I raised the concerns with regards to other witnesses before as well, and it's always met with, but we should be the parliament of the people and open to everybody. But, Chairperson, we do have a responsibility to protect Parliament from becoming a kangaroo court. I do not agree that it's the choice of Mr. Chetty if he is comfortable to continue or not. We should make that decision because we are at risk of and the problem lies with what the Honourable Souls say. We must test it. If we test the validity of the allegations made by Mr. Chetty, we're going to have a problem. The Honourable Matthys says that he can exercise his right to say, but this matter I won't respond to, it's in front of the court. Then we can just as well stand up now and leave, because everything that is alleged is in court, because even the allegations made are now in front of IPID. And the witness already attested to that now and said that his allegations with regards to the alleged wrongdoing in terms of these cases are now investigated by IPID. So we are in a peculiar situation where the relevance of this is also, it's really not relevant to our investigation currently. What is relevant, we can take note of, as other colleagues said, in the statement. Mr. Chetty is here, he confirmed that this is his statement. Let's take note thereof. Let's protect the integrity of this committee, but also of Parliament. And if we are going to go ahead, Chairperson, I'm very uncomfortable to participate, but Mr. Chetty must then also know that we are also in possession of an affidavit by Brigadier, he's now Mr. Raman Jalam, who is in prison currently, who's a co-accused in many of these cases. We have that affidavit. If we're going to test the validity of the wrongdoing, we can't do that without exploring also the counter allegations and the evidence that's also provided that says it's the contrary. And then we are exactly where the Honourable Breitenbach said we are going. And we are not a court of law. These cases are in the court of law. Let the court of law decide what is wrong, who's guilty, and who's not guilty. Thank you, Chair.
Good morning, Honorable James. And
Hi, good morning, Chair. Finally. I strongly agree. We had this discussion, like Honorable Vessel said, we had this discussion later last night when we left. And I think it's just shocking right now. I always look at matters and I put myself out there and I think, what would South Africans be saying right now about us? I think that's almost the most important things that comes to mind. These people have brought a witness before them twice. And today they start off proceedings by debating whether he should be here or not. That is a disgrace. That is an embarrassment. I think the evidence leader have been subjected to this, to his statement, and I think they should have guided and advised this committee on the best way forward. I genuinely believe, Mr. Chetty, that you will compromise your cases if you proceed here today. And therefore, I also state that as Action SA, we're also a little bit uncomfortable with proceeding. Thank you.
okay. Before I give the evidence leaders and Mr. Chetty to make statements, let me say this, that I understand that when you are members of Parliament, you are politicians, and Parliament is a political institution. And today we want to discuss a procedural matter, and a procedural matter which is clouded by politics. Number one, who brought Mr. Chetty here? Mr. Chetty was brought here by the committee. It's a decision of the committee, Mr. Chetty, that you must be here. And there is nobody who is going to pass the bag and want to blame the committee secretariat or evidence leader. The committee in its own meeting took a conscious decision. Ramano was there, gave us a report. So we must take responsibility, honorable members. I always tell you when I'm here that the chairperson speaks the decisions of the committee. And if you listen to the summary that Honorable Sols gives here, Honorable Sols has given you the whole summary of what the committee has done. This committee further, Honorable Sols has said that the public submission evidences will not be led by statements which they would have prepared with the witnesses, but the witnesses will bring their own statements here. The public submission witnesses. Mr. Chetty has brought his statement. Why do you want to hold evidence leaders responsible for a statement that you said public submission witnesses must bring their statements before the committee? He brought his statement. And so what the committee has to do is to look for the needle in the haystack, separate chaff from grain. If you know what your terms of reference are, go through this whole statement and then look for what is relevant to your terms of reference than to prejudice the witness, either through the committee process or through any legal process. We run an oath every day here, and the honorable members are the ones who must know the oath more than the witnesses. Because the oath here says that any information or evidence or document that the witness presents before the committee cannot be used against him anywhere outside the House of Parliament or a committee of Parliament, unless in proceedings of perjury. Because when he's here, he's protected by the same provisions of the Act that we read to him. That's what it is saying, the oath that we take here. Unless if I'm giving it a different interpretation. But what is being said here is that the information cannot be used anywhere outside Parliament or... So, but the long and short of it, honorable members, is that this man did not come here, this witness did not come here by his own accord. He is a decision of the committee, and the Secretariat has even reported before us. You know what happened? When they reported that the person who made a submission before the committee cannot be found, it was this committee which gave the Secretariat details to say, go and call these people. These are their details. And they went there and did exactly what you have instructed them. It was this committee, it was nobody, it was not a member of the Secretariat or the evidence, it was the committee that presented contact numbers, digits one by one, in a committee meeting to say, call them. And they went out and called Mr. Chetty, he came. He's here now. So there is no way we are going to be temerarious here and try to gerrymander our rules. We are going to proceed with Mr. Chetty, let him present what he wants to present before us. And after he has presented, if you decide to keep quiet and I will release him to leave and go back home. Thank you so much. We are going to proceed, no further discussions on this matter. Can we proceed, Advocate Arendse?
Thank you, Honorable Chair. I suppose that's the end of that discussion. I can't say anything further as the evidence leader about the process that brings witnesses before this honorable committee.
Don't comment on that. The chair has
Thank you.
has made a political statement. I don't want to put you on the crossfire. Honorable Sangweni.
Thank you, Chair. I also don't want to get caught in the political crossfire. Chair, can I ask, so we don't have this issue tomorrow? We're having 3 public participation witnesses. If my memory serves, there had been an issue that I'm not sure is Nicolette Ms. Prinsloo had raised about some of these witnesses, including Mr. Chetty and one witness that we are meant to see tomorrow. Can we request that before we maybe even break for lunch, that the Secretariat advises us on the witnesses of tomorrow and if indeed those witnesses should be? Because we had been advised against, Chair. Thank you very much.
Yeah, no, those witnesses are coming tomorrow. They are a decision of the committee, honorable members. Whether they come here to say anything or to say nothing, the committee has said they must come. So we are not going to change our decision at the 11th hour. We unless that they are unavailable, but any of those witnesses who is available for tomorrow, they are going to come here. Honorable Vessels.
Thank you, Chairperson. I just think it's important that we just remember that when the committee decides on the witnesses, we don't have the details, the statements, and the actual detail of what the case pertains to and what the witness is going to present to us. We raised the issue last week on when we received the statements of tomorrow's public participant witnesses. We raised the issue and we said we must look at that and the legal team must look at that because it does not seem relevant. And I repeat that, Chairperson, that I think we should, I support the Honourable Sangoni because they should look at that before those witnesses travel. And Chair, the same with this, I do not accept, with due respect, your statement that we decided. We did not have all the facts when we took that decision. When we get the facts, we can revise a decision. Thank you, Chair.
No, I hear you, but what is important, honourable members, you did not only decide. You decided and further instructed the evidence leaders that the public submission witnesses must bring their own statements here. Yes, maybe what we should be saying is that we could have said that let them look at those statements and advise the committee. But you said that no, they must bring what the evidence leaders do. They study the statement of the witness and look at how they can arrange it thematically. But without changing the whole statement or saying this must not go before the committee. So you can't want to apportion a blame on them for doing what the committee has instructed them to go and do. Honorable Nomval.
No, thanks, Chair. I hear your ruling on the matter. I disagree with you vehemently. We agree on witnesses, not on statements. We don't consult with witnesses. Witnesses consult with the evidence leader, and for a purpose. They don't consult with us. So it's wrong for us to be blamed for the work of the evidence leader. I still insist that the content of the statement, a person who can guide the contents, is the evidence leader. If it's not him, then who? Because by saying, Chair, witnesses can, public participation can bring their own statements to the committee. We're not giving an open-ended directive. That must be within the terms of reference, and because it means tomorrow we're going to wake up with a Bible here. A person who decides to submit a Bible to the committee and say, no, it's you committee members who said public participation can submit anything. No, there is guidance that must be provided by the evidence leader. I still insist you can defend him if you like, but I still insist, Chairperson, that the reason why we have the advocate here is for quality assurance. He must exercise his responsibility to say, this is relevant, this is not relevant, this is within the terms of reference, this is outside the terms of reference, not us. Because if you are putting the blame on the committee, then allow the committee to consult with witnesses on their statements before they appear here. We get statements here in the morning. So we give a go-ahead under an impression that further work will be done on the nitty-gritties by the evidence leader, not by the committee. It was going to be a different case, Chair, if when we make a determination, we make a determination with a statement of a witness at our disposal. To say, if they can submit statements to us and say, this is what the statements want to present, then take a decision of whether he must come or not. Then we can be blamed for the content of the statement. But we make a decision on the basis of what has been presented to us by the evidence leader, because when they present, they say, no, this witness wants to come and testify on A, B, C, D, and E. then we say, no, it's fine, we can go ahead. But there is no statement at our disposal. So I disagree, Chair. That is our strong view. But if there is an appetite of defending the evidence leader, then that's not my baby. It's fine. Thank you.
Let's proceed, honorable members. No, we are proceeding. Let me tell you how we are proceeding. The statement that you have before you, it's not a statement that has an input of the evidence leaders. You know, when evidence leaders consult with witnesses that you have identified who come before you, they draw statements. Some witnesses sit with their lawyers and draw statements and they submit to the evidence team. And the evidence team, when they lead evidence here, they select thematic areas on which they are going to lead evidence. So the statement that you have before you is not a statement that was written in consultation with evidence leaders. And that was your decision, that the evidence leaders have given you a statement that the witness has brought before them. And they have prepared their own notes on how they are going to lead evidence. So let's allow the evidence leaders to follow the thematic areas that they have prepared. And it's up to us as the committee to look at what is relevant to our terms of reference. Honorable Sols and then Honorable Breitenbach, you are the last.
No, Chair. maybe we must submit Bibles so that we can be reminded to be truthful. As the committee, even those public participation witnesses that's coming tomorrow, Honorable Vessels and Honorable Nomvalo must be truthful. We received it from the public. We brought it to the committee. The committee said, in the next meeting, table what is the content so that we make a decision. In the next meeting, I read the emails. The decision was made on the basis of that submission and a condonation was given. That's where we come from to this point. Then they had to provide their information, and now it's a matter of you must test what is in there. We must test it here. Whatever they present to us, are they giving us content that will assist us with our work? So we must not be untruthful and say we had no sight. This is public participation. It is not like the witnesses that is brought to be led by the evidence leader. So we are not defending the evidence leader. We are saying, and the secretariat, we are saying there are many things that we are dissatisfied with and we raise it. But today, this time, it is wrong to say the blame is on the secretariat and on the evidence leader. It is wrong today. Thank you, Chair.
Honorable Breitenbach, you are the last.
Thank you, Chair. I'm not blaming anybody. We find ourselves in this situation. I choose to deal with it as I find it. I am deeply uncomfortable with proceeding, and I request to be excused along with Honourable Kanabona.
Okay.
Thank you.
Mr. Chetty, are you ready to proceed?
Chairperson, I am ready. Thank you.
Okay. Thank you. Thank you so much.
Chair, we didn't hear. You must please let him state for the record he wants to. Knowing the information, and he's willing to do it despite what he knows.
Did you hear what Honorable Sol says? Can you raise your voice and put it on record? Are you willing to proceed?
I'm very willing, Honorable Member.
Okay. The honorable members have requested to leave and you occupy their seats.
Chair, you must say which honourable members and from which party have left proceedings. Because we've had so many people come here and they just tell us, I can't answer that, and nobody leaves. So we don't know how all of a sudden now there's a different stance of not wanting to be part of things. So please let it be clear, Chair. Thank you.
Yeah, I mean, it's it's unfortunate, but sitting here as the chairperson, I don't have any authority to detain persons in this meeting. Members of parliament, including witnesses. That is why the last time when we saw a witness standing up here and leaving, the least I could do is just to say, hey, Mr. Khanyani, ayo, Eloi, Eloi, lama sawatan, Khanyani, Eloi. There is nothing I can do. I can only say, why are you abandoning me? There is nothing more. So we are going to proceed, honorable members. Let's be humane enough. Mr. Chetty was here last week, and he spent the whole day with us. If you remember the time we made a decision that he must leave, it was towards the evening. And he spent the whole day trying to work on his statement so that it could satisfy the committee. And the committee met again, Mr. Chetty, on Monday and agreed that you must come today. You are here. We want to thank you so much for once again making yourself available, because we strongly believe that you have issues that you want to raise with us, and you believe they can help us in our work. So we are going to afford you that opportunity to raise whatever issue that you want to raise. You are under oath. We have read you the privileges that you enjoy here. I do not know, but that is how I understand the act, the provisions of the act that I have read to you. But because I'm human, I can have limitations, and I'm not infallible. If the provisions of the act that I have read do not cover you, I want to put it on record that you can't come and say the chair said this and that in the proceedings, and you want to use me as a defense. I think what must guide us here is that we are a constitutional democracy underpinned by what we call the trias politica, the doctrine of the separation of powers. That we do not make a call on judicial matters. The judiciary is the competent authority in terms of the doctrine of separation of powers that makes a call on judicial matters. And if you appear before a court of law, and the court of law says, but when you appeared before parliament, this is what you said, and they want to use that as evidence, they are the ones who are competent to make a decision whether the evidence you provided here in parliament is also admissible evidence in a court of law. And you cannot use parliamentary processes or mechanisms as a defense if there is a strong legal sentiment in the country that the evidence could be admissible before any competent court. So I just felt I must make that statement, because law is science, and science can be subjected to different interpretations. Like you see, when we are here in Cape Town, the direction of the sun is not as I know it in Limpopo. That is science. So it can be differently interpreted, but at the end of the day, it remains the same sun with 12-hour day and 12-hour night, whether in Cape Town or in Limpopo. So let's have that understanding. So you said that you want to proceed. We are going to proceed with you, and Honorable member has reminded me here that some of the witnesses who appeared before us, when there were matters that were still before the courts, they will respond by saying, I may not be able to respond to this question because it is before the courts. You get it? Yeah, so that you have rights as a citizen of this country. There may be a burning desire in you to share very important information with us, but your rights must not be trampled. And whatever case that you have before the courts, your chances must not be jeopardized because we would have asked you questions and maybe out of excitement or agitation, you end up responding to those questions and they jeopardize your chances. I just felt I must say those to you so that you can frame yourself in such a way that as a citizen with full rights, you have prepared yourself, you know what you want to come and say before us, and what you think can help us to further our terms of reference. Thank you so much. SC.
Thank you, Honourable Chair, honourable members. Now, Mr. Chetty, you are one of 70 accused in the what we described as the big case, the 335 case that was first opened in 2020. Is that right?
Yes, Chair. Yes, Counsel.
And then you are also one of 25 accused in case Silverton 143. You're one of 9 in Silverton 144. You're one of 23 in 145. One of 3 in 142. And one of 2 in 147. Are these other accused, are they aware that you are appearing here today and giving evidence before this honourable committee?
My family is, Chair, my family is, and some of the other members that I have access to is aware.
But the accused?
Yes, yes,
Or
yes.
some of
The
the family
accused.
members?
Yes, my family members are also accused
They're
in these
also
matters.
accused.
Yes.
And they know that you're here and they don't have a problem with you appearing?
No, they don't have a problem. And just want to put it on record, a couple family members and other accused also sent complaints to this committee, but they did not get any responses.
Now, some of the accused in all of these matters are also South African Police Service officers.
Yes.
Are they aware that you're appearing here today, or have they consented to you appearing here today?
I don't communicate with them often, only in court. I was in court 2 days ago, Pretoria Magistrates Court, and I did share it with, I think it was 2 or 3 of the accused that all are members in the police.
You're not concerned that some of your answers to questions or some of your statements that you may make voluntarily may compromise some of these other accused in these cases?
No, I'm not.
You're not
I'm not concerned because I am here. I don't think from listening to the other members that my annexures has been went through thoroughly because I'm here on the abuse of power based on the terms of reference by the IDAC, by the NPA, which I have reference to everything. So yeah, I'm not concerned.
Now, not that any person or any accused can be abused by law enforcement agencies, or in some instances in your affidavit you also reference magistrates or the judiciary. Not that that's justified, but all of these charges are very serious charges. Do you accept that? Whether they're valid or not, they're serious.
They are serious, yes, counsel.
And as one of the honorable members pointed out, that it is the prerogative of the prosecuting authority to charge an accused person. And that forms part of our rule of law. We've got, you know about the rule of law.
Yes.
We have, all of us have to conduct ourselves in accordance with the rule of law and with the Constitution.
Yes.
So given that these are serious charges and the committee cannot ask you questions relating to the merits of any of these cases, why would you nevertheless want to proceed to give evidence before this honorable committee?
Counsel, are you meaning evidence on my charges? Or evidence or the
Evidence in
merits of the
relation-
case?
In relation to the merits, that's the charges, yes.
Yes. The evidence of the case is in court. Sorry, the evidence of the case are also in my annexures, showing the duplication of charges. That is it. So I just want to just bring us back here. The case that was struck off the roll, right? 342A C was recycled and baby cases were made. So those charges that were struck off the roll, they just took out and recycled them and opened baby cases. That is why I'm here on the abuse of power. And one must remember, it's the same prosecutor, the same investigating officer, the same chief investigating officer. So they worked in concert. That is the main reason why I'm here about when we're going now to the charges of the case or the evidence of the case. They use the same evidence and charges in baby cases from a case that was struck off the roll. So the cases I'm facing in these small cases are all charges and evidence from a case struck off the roll. That is the reason why, one of the reasons why I'm here.
Well, then it begs the question. So what do you want this honorable committee to do about that? They have now recycled 335, which is the big case, recycled it into 4 or 5 other baby cases. And that for you involves a duplication of the charges. Is that your complaint?
That's my complaint. And as well, having multiple warrants of arrest against me approved on the same day by the same prosecutor, same investigating officer, signed by the same magistrate, taking me to different courts and executing it at different times.
Okay. But we also know then that the conduct of these prosecutors and law enforcement officers, that is also the subject of an IPID investigation which you have confirmed this morning.
Yes, Chair. But one must realize that this case that I opened was back in 2022, after I got the indictment of the case 143, where I was arrested in February. And the full cycle of this specific case of 12 of 7, it went all over. It even went to Parliament. I have my proof here, whereby it also went to the late Tina Jomet Peterson. And then I received the email. As we're going through the affidavit, it's all there. So why I'm saying, only the day before yesterday, I get a call from IPID stating the docket now must be collected and warning statements must be taken by these individuals. But let me take you a bit back. I received a letter from the DPP's office, 2024, December, stating that they declined to prosecute the matter. I then just asked for a nollie prosecution certificate. And now, I didn't ask them to review anything. The IPID investigator calls me a day before yesterday and says, I have your docket now, and I need to take warning statements. So initially, why did they give me the certificate not to prosecute? And 2 days, knowing that I'm coming here, now they want to go and collect the warning statements from these guys.
So you read something sinister behind this, that on the one hand, the complaint that you lodged against these officials, where it was decided not to prosecute, and you got a nolli prosecute, is that right?
I got a letter, not the certificate.
Not certificate
No.
yet, but they decided not to prosecute.
Yes.
And now IPID have opened up an investigation on the same complaint.
The case was always open. The docket was kept at the DPP's
No,
office.
but you said that the National Public
The
National
DPP.
Director, NDPP, had decided not to prosecute.
The DPP from North Gauteng,
from
yes,
the North
decided
Gauteng.
not to prosecute the matter. I then went to ask for a nolli prosecution certificate. We did not receive any response. I then sent Shamla Batoy a letter for the certificate in 2024 December. It's in my annexures. 2025, I received an email from an advocate, Erasmus under correction, stating that he's taking my matter under urgency. It has been quiet from then, but I did send him a letter asking, I want the certificate. I didn't ask you guys to review. You made your decision on not prosecuting the matter. So now, you sending me a response saying you're looking at it under urgency. It has been quiet since then. Nothing. Until 2 days ago. The docket is now back at IPID. And now they're calling the 3 suspects to collect their warning statements. I find it very surprising.
Yeah. So isn't that where it belongs? With IPID, whose main job is to investigate police or alleged police misconduct.
Yes, that's why it went to IPID.
And that is there with the appropriate body that's been set up in terms of our laws to look into that kind of complaint, the complaint that you've lodged. You've also launched a High Court application to have these, what you call splitting of charges from the big case and splitting them into baby cases. You've also launched an application to have that dismissed. And I assume you are being represented by counsel, by lawyers in these cases.
Firstly, Chair, 12/7/2022 has a history before I got the call 2 days ago. It has a history where it went up to the DNC's office of General Sabia, and where the docket was kept with him for a long time. The docket also went to General Labia's office. But I'm just saying there's a paper trail of where the specific docket has been going to and how the system has been abused. And I received a letter from the DPP's office not to prosecute. So then full stop. I didn't ask them to go and investigate the matter further. I didn't. And it just comes to my amaze now, 2 days ago, I get a call. The docket is given back to the investigating officer by a prosecutor to go and obtain warning statements. So why have I been frustrated from 2022, going all over, up to General Sabia's office? And only when General Mkhwanazi's briefing, I then realized the suspects in this docket is the same suspects that those PKTT, or what do you call it, dockets were going to at IDEC, to Dylan Perumal. So I have a full circle on what happened with that specific docket. 12/7/2022, yes. So it's just not now that the docket is now at Mr. Baloy, at IPID, and I must say, okay, fine, let's take it forward. To my understanding, there's a reason why the docket is now Is there a reason why the docket is now back in Mr. Beloy?
Well, it could be that the fact that you had indicated or they heard or know that you're coming before this honourable committee, maybe it's had the desired effect, that it's now with the body that is tasked with investigating these allegations of police misconduct.
Yes.
Maybe they are taking it seriously now. Because one of the remedies you would have had, absent the matter now being dealt with by IPID, would have been for this honourable committee. I can't anticipate the committee's findings or recommendations. Would be, for example, to say, we had a witness narrating a string of abusive or allegedly abusive conduct, and this matter should now be referred, must be dealt with by IPID. And that's where it is now.
I hear you, Chair, and I just pray that the process will be taken in obtaining these warning statements, because I also would appreciate the committee to call Mr. Beloy. Mr. Beloy was frustrated with the docket once he received it. Back in 2023, 24, under correction, he received the docket. I will appreciate Mr. Beloy coming in from IPID to explain what has happened with the specific docket. And also to put it on record, IPID has another case of mine, 353 of 11/2022 of extortion by the same suspects, where they opened a string of cases against me. It's in my affidavit. So yes, I'm here on the abuse of this IDEC officials, taking me to different courts all over the province.
Maybe can I jump to something maybe more exciting, if I may put it that way. You say it's in paragraph 44 on page 74 of your affidavit.
74.
Yes, the very last paragraph actually. You say that you want to put on the record that Mr. Paul O'Sullivan contacted you regarding an article of General Masemola and a Louis Vuitton handbag. He was looking for information that could assist him against General Masemola.
Yes.
Why did you deem it necessary to put this into your affidavit?
I think it's about a month ago. It's on my annexures, if you refer to it. I was at home and I received a call, a WhatsApp call, which I didn't take at the time. I didn't know whose number it was. I then called it back, I think about half an hour later, and just before calling it back, I received a message from that number stating it's Mr. O'Sullivan, and he wanted to talk to me. I then told him now I was busy at a prayer and at home, and I said, no, I will talk to you tomorrow. I spoke to him the following day, and then he said to me that he's referring to an article that he has seen. I think it's in the Daily Maverick regarding Louis Vuitton handbag. And then I asked him, why is he calling me about this article? He says, no, he wants information against General Masemola. And I just told him that he is aware that I'm coming to this committee, and I can't assist him in any way. And that was the end of the conversation. I did attach the WhatsApp conversation that he sent me on my annexure.
Did he call you perhaps because I'm trying to find the person's name, Mr. Rama? He's been convicted, and I think and he's one of the accused in one of your matters.
Mr. James Romangulam.
Yes.
Yes, I was arrested with him in 2020,
Yes.
and then I was again arrested with him and others in case 14320 in 2022. The execution of the arrest was in Silverton, but they took us to Palmbridge. and they detained the both of us. With Beluchan putting an affidavit, I think it was his third supplementary affidavit, stating that I want to kill him. James and I want to kill him and the team, with no case number or anything. And then James and I was in prison, I think, for 39 days. We put in a high court application in for bail. I got, and he didn't get, because while in prison, we were detained. I think it's the 10th day, Sergeant Beluchan and the team came to arrest him again while he's in prison, and took extracts again out of that case that was struck off the roll, but this time took him to Randburg Magistrates Court.
Now,
Yes.
I want to ask about, what did you say his name was, Mr.
James Ramanjulam.
Ramanjulam?
Ramanjulam.
Now, he is still one of the co-accused in several of the cases that's pending. Or which case is he a
Counsel, to be honest, I saw James in court the last time in Palm Ridge in 2022. He was never brought to court. I only came to find out recently there is a 204 a witness, and he was never brought to court, and I don't know the procedure. Did he just disappears, or was he supposed to be brought to court and charges withdrawn, or saying that he's a state witness? But I've never seen him. I did see him after that in 2023. I went to visit him in prison. Yeah, this time in Kosimampo.
Is he an accused in 335, the big case?
Yes.
And that case has now also been brought back.
Yes.
It's been brought back. Now, his affidavit was also next to O'Sullivan's affidavit that came before this committee. Okay. So that's why I'm curious to ask you, and if you don't know, that's fine. As a basis, perhaps, why he would have wanted to call you in connection with this allegation of a Louis Vuitton bag.
Okay. Counsel, when I opened case 12/7/2022.
Okay, that
Right.
for the
Yes.
sake of the committee. That's your complaint.
Now, and explain to why he contacted
this
me.
is the complaint against some of these.
Yes, the IDEC officials.
Yes.
The right, these three guys. And I found out that the investigating officer did see the national commissioner about this case that I've opened, and the investigating officer then told me he did see General Sibia. Right. It came to my attention that this IDEC official, Sunil Beluchan and Dylan Perumal, was going and using this case of the Louis Vuitton handbag to get appointed at the police. I don't know which section it is, but to be appointed without following the process, right? I didn't send a letter to the National Commissioner, which is in my annexures, telling him, General, you are aware that these guys are the suspects in the case that are opened. And it came to my attention that you are on the verge of appointing them. And regarding that letter, it then got leaked out to the news. It was a news article. And that's how O'Sullivan, or that's why maybe O'Sullivan tried to contact me, thinking that I have evidence against General Masamula about a Louis Vuitton handbag, and not asking me anything about the IDEC officials. That's
Okay.
it.
The reason why I also went straight to that allegation is because it also seems to be the case that you are connected with some high profile persons who's either with you and accused, or they have been accused, charged, prosecuted, and sentenced, like this other gentleman we referred to. And I wanted to lead on from that. How do you get to to see and to speak directly with a very senior official like General Sabia.
Right.
Because, again, you're going to answer. It's not as if your complaints have not been heard or listened to by General Sabia, General Masimola. You've gone right to the top, isn't it? You've complained. So my question is, Sabia, how do you get to see him? How do you go? Do you phone him up? You WhatsApp him and say, I would like to see you? He's a busy man.
Yes. At that time, when I opened the case, the investigating officer then, Mr. Sergeant Shlangule, made contact with the National Commissioner, right? And that's when he told me he had a meeting with General Sabia and the National Commissioner regarding this specific case. And that's when I went personally looking for where General Sabia is. And many times I waited for outside his office, asking him, what's the status of my docket? That's how I met him, by the investigating officer telling me that the docket is moved now to organized crime. He's no more at provincial. He's at national organized crime now. But the docket is gone with the investigating officer under General Sabia. So I didn't know politics. I don't know politics. I don't know the system. Only after General Mkhwanazi's statement, I then understood why nothing was done to 12 of 7. Because General Sabia was very aware of the suspects and so forth. So I then understood why. So the investigating officer, Mr. Shlangule, should be called in, and he will explain how it got to General Sabia and what happened from there. Yeah.
But what we do know from your narrative that nothing happened.
Nothing happened. I complained to Inspectorate. I met General Jacobs. I went there with one of my co-accused in our case 143, and we opened up a case there at Inspectorate. And the docket was then taken from General Sabia's office to Inspectorate to General Jacobs' office, and Colonel Phillips attended to us, myself and Marcel Mani. From there, Colonel Jacobs said we need to sign a consent form and send this docket now and others. It's not just 12 of 7, there's others against the same officials to General Libya at the Hawks. I left it. After some time, I sent the mail. I received the mail back from General Libya's office that they're not going to handle with the docket anymore and others. It must go back to General Sabia. And this is not happening overnight. It's taking over time just to frustrate me and make me not worry about the docket anymore.
Now, I'm sorry, I'm not getting his pronunciation.
Ramanjulam.
Ramanjulam. Now, Mr. Ramanjulam, you haven't seen his affidavit.
When applying for my bail relaxation in Palm Ridge, was last year, his affidavit was disposed to my legal counsel, which I had no interest in reading. Then 3 days ago, I think Mr. Ramanu sent me that same affidavit. Yes, but I did not read it.
Oh, you didn't read it, so
No.
I can't ask you about it.
No, I didn't read his affidavit because I know where that is based on. I know this man personally. I know what this IDEC officials did to him. So mentally, I was not willing to entertain that affidavit. I was concentrating on my stuff, my affidavit, and my annexures, because it's going back for many years now. Because I have a paper trail on everything. I didn't want to go and frustrate myself with his.
Because I think you told me in our consultation that we had, the brief one, that you know that he was tortured. And so you didn't read his affidavit because you assume that the affidavit was made, or whatever he said is under duress?
100%, counsel.
Okay. So the reason why I asked you whether you had seen his affidavit is that if you do take the time to do that, maybe you should, before your various trials come up. He makes allegations against a lot of people and a lot of important people. And he makes allegations about the Louis Vuitton bags. You've seen that?
No,
Oh, sorry, you haven't seen it. And you'll also see if one goes through the list of 70 odd accused, and especially the natural persons, in the big case, the 335 case, he also makes allegations against them. So I think you should read it, especially if the state intends to call him as a witness. He, as we know, he's been prosecuted and he's a convicted criminal.
It's the first time I'm hearing that he is convicted.
You don't know he's in jail?
Nope.
Have you pleaded in any of these cases?
No.
So these cases, you don't know how far they are with investigating them, whether they're ripe for trial or anything like that.
From my last appearance 2 days ago, Advocate Shabalala puts on record that he is postponing the matter, reason being on the outcome of my High Court application. Because the High Court application has merits on all these baby cases and the 335 that he has brought back on the roll.
Now, I'm going to not ask you any questions in relation to any of these cases, because it seems to me to be a pointless exercise, given that we can't ask you about the merits of these cases. So I'm going to give you an opportunity, and then I'm going to end my questioning, to perhaps try and summarize the conduct of the various officials that you complain of, and perhaps with the prosecutor in this case, in all these cases, Mr. Shabalala.
It's fine. Can I go
Yes.
ahead? Can I start at the beginning, counsel? Right? And then I can run you down to how you obtained 3 warrants, executed at different times, how he lied to the judge, he perjured himself. I have all. Can I?
Yeah, but I wouldn't. Obviously, I ask questions and
Okay. Can
speak subject to the direction of the honourable chair. But we need to restrict you to summarize the conduct of each one: Baluchan, Perumal, Shabalala, Low, because that is at I think you conceded that, not conceded, but you said that at the beginning, when we summarize these matters, that's at the heart of your complaint, is that these 4 officers have made your life and your family's life a hell, isn't it?
Yes.
And I think you characterize it.
And the other
summarize
accused.
it as, yeah. So maybe just briefly on each one.
Okay. After the case was struck off the roll in 2021, 2022 February, 7th of February, Baluchan, Perumal, Shabalala, and the same magistrate signed a warrant. There was 3 warrants: 143 of 1 2022, 144 of 1 2022, 145 of 1 2022. Counsel, you must remember, all of these warrants were signed on the same day by the same magistrate, same prosecutor, same IO, right? The first warrant was executed on the 7th of February, 2022. I was then taken to Palm Ridge Magistrates Court, but on the warrant of arrest, it says, take me to Court 16, Pretoria Magistrates Court. they rather decided to take us to Palm Ridge Magistrates Court, which is 95 kilometers away from Silverton, right? I was detained with others. On the 25th of March, 2022, I was released on bail, right? On the 4th of June, 2022, Beluchan and the team, it's the same people we're talking about now, Perumal, Beluchan, Shabalala. On the 4th of June, 2022, they're outside my house. Happy anniversary. Because the initial arrest of the big case truck of the roll, they arrested us on the 4th of June. It was a Saturday. And when I got to the station, there was many other people there. That was on case 145. While processing me, he said, keep your bags packed up. I'm coming for you next week. Monday, getting bail. I got out Tuesday, Wednesday, Thursday, Friday, on my way to sign my bail, under my bail conditions. I get a call that they're outside my house again, executing the next warrant, 144. So that is abuse of power. Why did they not execute these warrants at the same time on the 7th of February?
But is 144 different to the charges in the
Same charge, just different case number. Same day, everything is the same, just the case numbers changes. Same magistrate, same prosecutor, same IO. Now, when
from the big
yes,
335 case,
yes. Now,
where you had already been arrested and appeared in court
yes,
on those charges.
yes, and the case got struck off the roll. Right now, on my bail application in 143, when they first arrested me on the 7th of February, right, in Palm Ridge, right? Magistrate Fenter refused my bail. I then did application in the High Court. Judge Musla asked Shabalala, the transcripts are here, is there any other pending cases against Chetty? He said no, but he rather had 2 warrants of arrest in his back pocket. That is what he did. And also put in mind that while again detained with Ramanjulam, we are still applying for our bail at the High Court. They arrested him again, whilst in prison. So that's why Ramanjulam abandoned his bail at Randburg. We're sharing the same cell, so I knew everything that he's doing. And he had to abandon the bail at Randburg. They brought him back to prison, and then Judge Musa says, no, he needs to sort the bail out in Randburg before coming to him. So I got out on bail, and he didn't. Now, after my arrest, the last arrest on 145 from those 3 cases, I then opened 1207 in July. And then I filed papers in the High Court. That is a duplication of charges. In retaliation, Beluchan called me the next year's day, it's there. And he said that me and others must appear at the NPA building for a string of SARS matters that he has opened. But at the same token, earlier that year, SARS sent me a letter or correspondence stating that they're doing an audit, and that's when he told me to, then I refused. It was just him, his colleague Ayanda, and I just refused, and I walked out of the office. There are many cases that he opened, the SARS matters. That is still in 2022. 2023, when I sent General Masamula the letter about his appointment, that's when retaliation came again. They arrested me again. But this time, the warrant is signed by Paul Lowe, right? But prior to that, on the 15th of February 2022, the investigating officer, Mr. Sriangule, called Mr. Shabalala to obtain a warning statement. And the following morning, Shabalala calls the investigating officer and says, General Sabia says you don't have to come and collect the warning statement. Only to find out, which I was told after I got arrested, Polo, I don't know, it's Matthew Sasoko, had a meeting with General Sabia regarding my case and obtaining the warning statement or proceeding with that case against this IDEC team. I didn't understand at that time what's going on because after I got out of prison, General Sabia told me that. This is what happened. Yes, Sabia. And he told me that. So then, when I got arrested, Sergeant Beluchan and the team puts an affidavit that I want to kill them again. Him and the team. And they just did this to silence me. Because in his affidavit, he states that I'm complaining to media houses and I'm complaining to the National Commissioner and Parliament. All my complaints are there. Complaining about them and nobody attended to me.
Yeah, your complaints is at paragraph 5.3 on page 16, where you reference your complaints to the National Commissioner, the Portfolio Committee on Police. I think that was when the late Timothy Peterson was still in jail back then.
Yes,
And also then the Hawks, the Directorate of Priority Crimes, that's severe.
No, General Sabia was the head of organized crime at that time. He was the head of organized crime.
So you do, and the conduct that you've described in the few minutes that you. Sorry, my microphone is off. Sorry, Chair, I didn't realize my mic. Should I repeat my So the conduct that you describe, Mr. Chetty, is also referenced at paragraph 4.21 on page 13, where you say the conduct of Perumal, Belichan, and Shabalala leaves much to be desired. I am being portrayed as a perpetual offender with numerous cases pending before the courts. I submit that the pending cases amount to one case, which stems from the investigations and or contents derived from Silverton case 335/5/2020, and all this was done to spite me, and at the time it was on 1 June 2022. And since 1 June 2022, you say that this is continued.
Yes, Counsel.
But when you've been arrested and you appeared before the courts in various matters, the relevant certificates and warrants of arrest, did you see them? Were they shown to you? Did they at least appear to you to be warrants? Did they appear to be authentic?
Counsel, when we first got arrested on 1/4/2022 and taken to Palmbridge, my counsel did bring it to Mr. Fenter's attention, the magistrate, that this merit is coming from a case struck off the roll, and we are not supposed to be in this court. We're supposed to be in court 16 in Pretoria. And Magistrate Fenter looked past it. He looked past it. He didn't entertain it.
So is that your, what specifically is your complaint against, you reference Judge Musa, Magistrate Venter, and I think one other magistrate also.
Right. Go ahead.
Is it? Do your claims against them? Is it because they ignored what you were saying, didn't take into account what you were saying?
No, firstly, Judge Musa, what I'm not complaining about. I'm saying that he asked Shabalala that asked him if there's any other pending cases against me, and Shabalala lied and said no, there's nothing. But he actually had 2 other warrants in his back pocket. Right? Magistrate Venter, he's the one that opposed my bail in February when we appeared there the 7th. Right? On baseless allegations stating that I want to kill the team. On Beluchan's 3rd supplementary, I was there on a fraud matter, but on his 3rd supplementary, he says, now I want to kill him and the team. Right. Magistrate Venter entertains it. We move on to my bail relaxation, which happened last year. After Magistrate Venter has opposed my bail, we were then moved to a different court. Right? And I requested for bail relaxation. And the magistrate said then, submit your documents to Advocate Shabalala, and I will get everything, and we will sort it out. In the new court where I'm attending now. I never seen Mr. Venter after my bail was opposed. Never seen him again. Last year, after filing documents up and down, maybe it was on 4 occasions, sometimes Mr. Shabalala does not appear on the relaxation matter. We then go to the specific court. I think it's Magistrate Keswa. It's in here. And she then says, no, go to another court. The advocate and I goes to this other court, and amazingly, I'm standing in front of Mr. Venter again. I then tell my advocate, no, this is the magistrate opposed my bail. So we can't stand in front of him because he made his mind up already. And we then put an application for him to be removed.
So are you saying that a magistrate who refuses you bail, normally there'll be a bail hearing, did you get an opportunity to give evidence, submissions, and the prosecutor would also make submissions or sometimes lead witnesses, and then the magistrate would make a decision.
Now we're talking about initially.
Yes.
Mr. Venter. The whole application was done in front of him, and then he declined to give me bail.
Yes.
Yes.
Yes. So you say in another bail hearing he must be recused.
The relaxation of my.
Whether it's the relaxation, which is even which is not a denial, but just a relaxation of the conditions, that he should be recused.
On his behavior and the basis that I have on why he opposed my bail, I then spoke to my counsel and said, you know, this magistrate is not going to entertain anything regarding my bail relaxation from the IO, which most of the time he gives me a problem, so I just stopped asking him. And when going back to Mr. Venter, the transcripts will talk for itself, whereby he says that he already made his decision on refusing to step down before hearing our arguments. And that's when I then told my counsel to abandon the bail, because he says it on record. There's no need for hearing of arguments. My judgment is made. So that's when I told my counsel, please, let's just abandon the bail.
And your other complaints against any other magistrate or presiding officer?
This is specifically on Palm Bridge. Other magistrates, you know, Advocate Shabalala just goes with the charge sheet and he just bombards any court. Counsel, I know you don't have a lot of time, but if you can see that a lot of times he keeps a charge sheet with him. A lot of times me appearing in court, there's no charge sheet. We sometimes wait for 2 hours, 3 hours. He says he needs to go and collect it from his office. Only for me to understand recently that the charge sheet supposed to be staying at the court. So this is normality for him. This is normality for
Are
him.
you, in all these hearings, are you represented by counsel?
Yes.
So what does your counsel say about this conduct?
This is totally abuse of power. And that's why my counsel has put the application in. And regarding my application, it was put in 2022 on the removal of these matters. In 2023, this is when we supplemented it, only to find out in 2024, early 2024, the supplementary has been deleted off case line. Right? We then uploaded it again, added the annexures. Last year, Shabalala responds to the supplementary affidavit, but when we appeared at the court in June, was it last year, the Shabalala and the counsel of the MPA says that our supplementary and our annexures has been deleted. So one asks, how did Shabalala then respond to my supplementary and annexures when it's deleted? Because his affidavit is there, responding to our supplementary. But when getting to court, they tell the judge that there's no supplementary or no the annexures.
Now, we know that the big case, the 335 case, Silverton case, that case has now been re-enrolled. And there was a decision to re-enroll the case. Is that because the racketeering certificate has now been authorized or issued, which wasn't the case initially?
Okay. Counsel, the case was struck off the roll 25th March 2021.
Yes.
The basis, the state needed more time to obtain a racketeering certificate, right? From my understanding, the state could not get a racketeering certificate. That's when they opened the baby cases, 143, 44, 45. They then realized that we found out what they did. On the was it the end of July, we then received a J175 to appear in Pretoria Magistrates Court. The summons is attached, the J175 is attached to my annexures. Right?
Yeah.
We then appeared at court and they gave us a CD with the summons. But this time, it's no more 655 pages, which was initial, it's now 450 pages. So it's common sense that they took the charges from that original case, they took out those charges and they opened the baby cases. Now that's why the case being brought on the roll is less now, the documents are less. But now,
What are you saying, that the baby cases collectively or together make up the same number of
charges,
pages or charges as 335?
100%. And there's proof here. Now, when the case was struck off the roll,
Now, how do we, as a committee, determine that that is irregular or unlawful or as you describe it, irrational?
the magistrate gave an order with 342A.
This is not.
Yeah.
I would expect. I don't know, but I would expect this to be part of your argument in the High Court, where your application is pending to have these charges
Yes.
set aside.
You know, counsel, I'm not here to prove my innocence. I'm not here. I'm here to show the abuse of power from IDEC, the NPA, the SAPS, the judiciary, whereby I have proof of how does one bring 40 142 people to court and you're not even on the court register. We're not on the court register. It's attached. The court register is attached on the day. I requested for transcripts from the transcriber on the day. It's attached there. I then go to the clerk of the court and request return of service and so forth on the J175, on that case being brought back. Up to date, nothing. The summons that we received, I approached the government printing works in Vasahi Street. They referred me to a deputy director. His name is in there. The email is attached. Whereby I went with the summons and he told me this thing has been superseded in 2014. Meaning, it's no longer valid. The summons we received, there's no signature on it. There's no signature. There's no charge. Just to put it, counsel, this summons was drafted out at a Protea Hotel. I attached the location sent to me by Nico Williams. It was sent to me, and I went to go and collect the summons because the first time they wrote the summons out, they had a problem. So they asked me to come back. He sent me his location, and he's busy sitting with a stamp from the court, right? And stamping J175s in Protea Hotel in Hatfield. It's Protea Hotel, yes. And whatever I'm saying here, counsel, my attachments are there. So me and everyone else is appearing for this 335 case, actually illegally, where we're not even on the court books. And I personally, it's not getting from a third person. A lot of this information, I've done it myself over the years. So it's not anybody throwing documents under the table or anything like that. If you can see the summons that I went to Vasahi Street, there is a paper trail. If the committee wants to go and have a look and request government printing works to come, they're going to tell you the same thing as the guy sat with me and showed me on the system. The summons has been superseded in 2014. In Pretoria Magistrates Court, in other courts, the summons that we received is outdated.
Tell me, I'm looking at the section of your affidavit which deals with, it's on page 51, paragraph 11.1, SARS Financial Institution, and that's Silverton 353/11/2022. Does that relate to the charges of tax fraud?
Yes. That specific case that I opened, I then went, after my arrest for the SARS matter, after these guys called me to the NPA office and signing these warning statements for these SARS matters, I then went back to General Sabia's office. I didn't see him personally, but I saw one of the colonels or brigadiers there, and he told me he will send an investigating officer to come and take my statement, which he did. I then received a message the next day with the case number of this SARS matter, and I am aware that this case of 353 has been investigated deeply already by the investigating officer. Me as a complainant, she has told me everything that is, or most of the things that is transpired in this specific case now. But she has blockages at IPID. Blockages because she has been going to Eastern Cape doing investigations, and as she's getting momentum, she has been stopped by IPID, by her seniors, stating that there's no budget to go to the Eastern Cape.
The matter that's before the High Court, that matter was taken there on the 19th of March, 2024.
Page number?
Page 58, paragraph 12.10. And that matter was struck off the roll for a second time by Madam Justice Newkircher for a second time. So as I would again assume that it was struck off the roll because of a lack of urgency, but the matter, has it been re-enrolled? Have your lawyers put it back on the roll?
Now, counsel, this matter that you're referring to has to do with my AFU matter.
Or the asset forfeiture?
Yes.
It's a different matter,
But it emanates from,
although it's related.
it emanates from 335 of 5/2020, just as I'm telling you about the summons that we received. And we were brought to court illegally, right? Right. So what Sergeant Baruchan and the team does, his affidavit is there. He uses a different court case number to go and apply for this AFU order on a rule nisi. His affidavit is there where he misleads the judge completely, he lies. He gets the order. Fast forward, we go to court, the matter is struck off the roll. When the matter was struck off the roll, the curator, Mr. Sean Williams, was supposed to release our assets. And I'm not talking about mine alone, we're many in this case. Under correction now, I'm not on the right page. The case was struck off the roll 3 times, if more. I have an email here from Advocate Wilson, who works with Advocate Shabalala, Low, and I will explain that later on, that he sent an email to the curator stating that he is aware that the curator is in possession of all our assets illegally because the case has been struck off the roll. And he's willing to keep our assets until the case is back on the roll, reinstated. Now, one can see here that once the case is struck off the roll and the system, let's call it the system, IDAC, these guys, don't get away. But the next week, the case is back on the roll under urgent. They still don't get away. They still get struck off the roll. They do it again and again. Now, this is completely abuse of power, whereby the curator is appointed by the master's office. He's not appointed by the NPA. I've been to the master's office. Unfortunately, I didn't attach so much information here. My records is at the master's office. And counsel, just to put it on record, when I approached the master's office, they said, yes, this is illegal. So I asked them, what is the remedy? My assets are frozen. I have nowhere to go. They're telling me I should go to a high court myself and do an application. What knowledge have I got to do an application at the court now for what I'm telling them? Because they were aware now that, and they even took the documents from me of the fake summons. We didn't actually appear in court. The application was made to the AFU to court with a different court case number, which is not appearing initially. But where I'm getting at, the Mr. Wilson tells Mr. Wilson and Nicole Peters, because she works with the IDAC at the AFU, tells the curator they're aware that he has our assets illegally. Yeah?
Is that the complaint that your dad lodged originally?
It has to do with the same curator.
The curator, yes.
It has to do something. I didn't even read my
So that
dad's.
was originally the complaint that he lodged. Yeah.
Now, my main thing is when it's abuse of power shows with the NPA and the curator, whereby Mr. Wilson took instructions from Mr. Williams took instructions from Wilson, stating that, we know you got these things illegally, basically, but keep it until we bring back the case on the roll. So they carry on putting the case back on the roll until they get what they want to reinstate the rule nisi. The court orders are there, it speaks for itself.
But Mr. Chetty, you are legally represented in all of these matters.
Counsel, the system, I have proof. If you want, you can take me by my hand.
Too much for your legal counsel.
No, you can take me by my hand. The members can take me by my hand. And all of General Mkhwanazi's allegations, whatever his briefing is, I can physically take you and show you what is going on. And I'm not representing myself here. There's many people behind me, and also people have died. There's people in 335 that have died because of this abuse of power by Beluchan, Perumal, Shabalala.
Okay. Thank you, Honourable Chair. I thank you, Mr. Chetty. I have no further questions. Thank you.
Okay, thank you. I was going to speak standing. So at least the microphone is now on. When you say you have no further questions, Advocate, do you mean you have come to the end of presentation of evidence
Yes, sir.
along the thematic areas that you have prepared?
Thank you. Yes.
Thank you so much. Mr. Chetty, you have 20 minutes before we break. Can I check with you if there is anything that you think you want to bring to the attention of this committee? The senior counsel has done what he felt was relevant for the work of the committee. And if there is anything that you think is also relevant in your own accord to the work of this committee, you can share with us. And if you are satisfied with the manner in which evidence was led, you can just say, look, Chairperson and honorable members, I think we have presented what was meant for this committee. Thank you.
Thank you, Chairperson. Right. In May 2021, James Romangulam opened a case against Sergeant Beluchan and Dylan Perumal. 97 of 5, 2021. There is a warrant of arrest against Sergeant Beluchan. Now, if you go back to the date, 2021, this was all in retaliation to arrest James Romangulam and others. But now again, let's go back to 97 of 5, 2021. A warrant officer went to go and execute the warrant in East London. Polo, Richard Tyler Shabalala, Perumal, Brigadier Titiwe. I think it's in his statement, the ex-Provincial Commissioner of Eastern Cape promised that Beluchan will hand himself over the Monday morning. Up to date, he has never appeared in court on this warrant of arrest. Now we're going back to 2021. What happened from there? We got arrested, I got arrested, and a lot of things has happened from then. So we go to 2023. I went to the magistrate's court, and then I went to the clerk of the court and I queried this case number. And they came back to me and said that the case is still, the warrant is still valid on Sunil Beluchan. I said, okay. I then went back to Pretoria West Police Station. And the station commander was not there. I requested to see someone that can assist me with this case, only to find out this case has been undetected. And there's a duplicate docket open now. So I was confused now because I'm aware there's a warrant of arrest that's there, and now there's a duplicate docket on the same case, 97 of 5/2021. I went back to the magistrate's court on one of my appearances because I'm often appearing there on these different cases. And I asked, like, what is going on here? This was, I think, late 2023 with this specific case, because now I'm aware there's a warrant of arrest, and now the case is closed as undetected. So I asked myself a question, doesn't this play with the statistics of the records of the SAPS? Someone then came to me when I appeared at court, and they gave me a letter signed by Nico Williams that collected the docket from DPP's office. The same docket, 97 of 5/2021. The letter is in my annexures. He took the docket and went to go and give it to Sergeant Baluchan, who is the suspect and is in possession of his own warrant now. Now, I did bring this to the attention of IPID. I did bring it to the attention of IPID, and the investigating officers are aware of it. Now, Nico Williams came from Eastern Cape, who is one of the team members of this IDEC team. He arrested me many times. He takes the case to Zwelicha and its attention to Brigadier Perumal, who resigned from the police in 2020. So this docket of 97 of 5/2021, instead of it being in Pretoria West, it's in Zwelicha, and it's in the hands of Sergeant Baluchan. Now, this case is from 2021, on May. How many arrests has Baluchan made, having his own warrant of arrest with him? He arrested senior politicians. I've watched on TV, I was shocked. The same team again. And recently, I've seen on news how he arrested General Kumalo. But I asked myself a question. Now, this guy is untouchable. He has a warrant of arrest where he's in possession of, right? But he's busy arresting people and taking them to the same court where he must appear.
You mean his own...
warrant of arrest. It's J50.
So he must arrest himself?
No, he got a docket with himself, so nobody can arrest him. He sent Nico Williams. The letter is here, where Nico went to collect it.
So what you are saying is that a warrant of arrest has been issued, and because he's the one who receives those warrants, he's keeping it with himself.
100%, Chair.
So let's say, so that we do an illustration for people to, if Honorable Ngola is the one who approves warrants, or he makes a decision that I must be arrested, and then when he has signed, and then for the warrants to be executed, they are sent to my office. And I'm one of those people whose warrants have been signed for execution. And then I keep my warrant, but I may release the warrants of other people. They get arrested and I don't get arrested because I'm having my warrant with me.
100%.
Who signed the warrant?
Pretoria Magistrates Court.
Let me say, before the warrant went to his possession, who signed it?
Who signed
the warrant? Yeah.
Meaning the warrant was there, the arrest was there. Who signed for the docket to be taken to him? Nico Williams. who is part of this IDEC team. It's one of his
So,
close
so
friends.
if this committee has to ask questions, who is the authority that we must address our questions to? To say, we hear that you have signed this docket, and there is this warrant in the name of Lakhanyane that is out, but it's not being executed. Who is the person that the committee can write to?
Chairperson,
Because
the owner of those
my
warrants,
understanding is that when you share this information with us, you are sharing this information with us to say, in your terms of reference that you are investigating, there are these corrupt practices that I'm observing in the system. I understand you correctly? And you, maybe as Parliament or as a committee of Parliament, there is a way you can intervene. Is that correct?
yes, because
And so if we are to intervene, let's say we want to intervene, we want to write a letter for a written response to say, there is a witness who appeared before us. The witness has said the following. We want to know from you as the authorities, do we write to the DPP? Who do we write to?
to write to the National
Maybe
Commissioner.
before you, let's hear Honorable Ngola.
No, let me help, Chair.
Yeah.
I think part of what is important was Mr. Chetty is mentioning the magistrate who signed off the warrant of arrest. So the best way from where I'm seated is to write to the magistrate commission to communicate with the magistrate himself to confirm or corroborate whether he has signed a warrant of arrest in this name together with his name, so that we get that confirmation whenever we want to deliberate around it. We have got the evidence before us. Thank you, Chair.
Thank you so much. Yes, you heard
Chair.
what he said.
Yes, but from my view,
Do you concur?
no, from my view, this warrant of arrest is there. It has been floating around all over social media. But unfortunately, from my understanding, you need the original warrant to execute a warrant, right? I did approach the police station where the warrant was approved. But on the system again, I'm showing you it's undetected. But here, there is actually a warrant of arrest. And this police station is aware that there's a warrant of arrest, but they is too scared.
Which is that
Police station, Pretoria West detectives.
And then who do you say is the relevant person there who can explain what you are saying?
The station commander should be aware of everything.
And who is that station commander?
I don't know who's the station commander. But the warrant of arrest is there, and he is in possession of
it's
his
fine.
own warrant.
We had to
Yes.
let's afford Honorable Ngola. Maybe he can be helpful.
Yeah, Chair, I think even in that instance, because he has the name of the police station, he has the name of he has the dates and all the necessary details. So we may probably need to write to the Provincial Commissioner to give us that information because we want
we
it.
write to the National Commissioner.
Yes, we can.
He's the one who knows the people under his line of command or authority, who will then provide those details. You can proceed.
Chair, I think we didn't go through it. I first received, when I got arrested in February 2022, the 7th of February, in August, September, I received the restraint order by Advocate Wilson, Beluchan, the same team now. We're not shying away from anywhere, the same guys. That is in 2022. They gave me a restraint order, another AFU matter on items of mine. But then they gave me another AFU order, which was in 2023. And again, it was duplicated.
When you say AFU, what do you mean? Because
Asset forfeiture unit.
oh, yeah.
So they froze my things twice, again duplication, by the same prosecutor, the same Advocate Wilson. The same people. These people are not shying away. They're not. It's not changing. The same people. And at this time, when I received my summons, the people that approached me was from the NPA with no number plates on their car. I sent a letter to the security at my estate. They said these people forced themselves entry. When receiving my summons, the sheriff, the lady that she says she's from the sheriff, gave me my documents, and I said, "Is there no receipt or must I sign?" She said, "No, you got yours, I got mine, bye."
So you want to say you were ill-treated?
No. I'm saying I was served the summons illegally, number one. Number two, it's the same.
Oh.
It's the same advocate, Mr. Wilson. And he called me directly asking if I received the
You
summons.
categorize it as unlawful action.
Yes. But now we're talking about the same team,
Yeah.
the same people.
Yeah. So, don't you think that such matters are matters that you must raise? Do they fall? Do they go together with the case that has been opened?
It is in my IPID case. It is there, but only 2 days ago I get a call now from 2022 that it's with the investigating officer now. So up to 2 days ago I was still hanging in limbo, not knowing what's going on.
Yeah, I'm saying that we may not be the relevant forum where you raise those issues, because if they are with IPID, it's a matter between you and your lawyer that when you appear before IPID,
yes,
you raise those issues for them to make the determination on the lawfulness or unlawfulness of the actions of those officers.
You see, Chairperson, I'm just here to show the abuse of power. Just court things that I'm sorting out. I will sort it out in court.
I agree. Let me tell you, because some of these issues now, they do not end with the currency of the ad hoc committee. Even after the lifespan of the ad hoc committee would have come to an end, you still have Honorable Cameron, who is a member of this committee, who is the chairperson of the Portfolio Committee of Police, that plays oversight. You have Honorable Ngola, who is a chairperson of the Portfolio Committee of Justice. So any citizen of this country can write to them as an oversight organ of Parliament and say, there are the following matters that I want to bring to your attention. And if you feel that they are not doing their work, you can still write to the office of the Speaker to say, I have gone to the Portfolio Committee, I've gone to Honorable Member so and so, I did not get the relief that I wanted. No, I feel that I must now write to your office as the Speaker of Parliament. Yes.
Yes, I understand.
Do you hear
Thank
what
you.
I'm saying?
I hear you.
Yeah. I'm saying that I'm giving you a chance so that when you leave here, if during the presentation of evidence between yourself and the evidence leader, you feel that there is something which would have fallen between the cracks, but you think must not escape these proceedings, you give us that information to say. Within your terms of reference, also look at the following. Yeah.
Yes, Chair.
You can proceed.
So where was I? Chair, you must just take it in consideration. I was arrested 5 times by the same prosecutor, the same investigating officer. And I'm not talking about me alone. We are many.
Yeah.
Same prosecutor, same investigating officer.
At Pretoria West.
First arrested in Silverton. The case got struck off the roll. Né? We went to Pretoria Magistrates Court. Then again, 143. It was 143, 144, 145. Same Magistrates Court, Pretoria. The first one, we were taken to Palm Ridge, but the J50 says come to Pretoria Magistrates Court. They took us 95 kilometers away. The second one, after appearing in prison and then coming out on bail, he is executing it on the 4th of June, saying happy anniversary regarding the matter that was struck off the roll. While processing me, he says, keep your bags packed. He executes the next one, the following Friday. Is that not abuse of power? Being arrested so many times in a short notice, having these 3 warrants and not executing it at the same time, when there's the same charge, same prosecutor, same IO, same magistrate signed it on the same day. That's why I've been fighting. I've been sending letters everywhere. But no one has been assisting. Chairperson, I understand. You're saying write a letter. I've been writing. There's a paper trail of everything.
Did you write to them, the police and...
Yes, General Masamula, Andrea Johnson. I was amazed that Andrea Johnson knew my surname because she never responded to any of my complaints. But when she was here, she's talking about Chetty's allegations. But I'm like, wow, I didn't get no response from her. Yes, Shamila Batoy, she's aware of these cases.
Yeah.
You know, it's all there. It's everything
Look,
is there.
I'm not the wisdom of this committee. Honorable members are going to interact with you when we come back. And obviously, if there are matters, there are no team matters that you present here. And members even go to an extent of suggesting how they think some of the matters should be processed. So I hope that all that you are presenting with us members are noting. We are going to allocate them time to ask questions. You will respond, and they will suggest on how they think your matters should be processed. Is there any other thing except your repeated arrest that you say repeated arrest by same people, and you view that as abuse of organizational authority?
Yes, Chairperson. And also, the courts, how they manipulate the courts by bringing public. It's obviously, this has been happening for a long time.
Yeah.
You're bringing people to court, but you're actually not on the court register. You're serving a summons which is fake. And in my view, it has not happened the first time. It's not happened the first time. It's just that I maybe found out and I just carried on digging, saying that there are many people appearing in court nowadays, and I don't even think that some of them should actually be in court. It's just abuse of power.
Okay. Do you have anything or further, Mr. Chetty? It's 1 o'clock now. The members may want to break. We are going to Parliament. We are going to come back at 5. Can you check? Can I check if the time I allocated you would have exhausted the matters that you wanted to raise with us?
No, it's fine. It's fine. I'm fine. Thank you, Chair.
Thank you. Thank you so much. Honorable members, I'm coming back to you. We are going to come back to our proceedings at 5. We are going to resume at Good Hope Chambers. Let me see. How many of you will want to ask the witness questions? Okay, no, we have a reason to come back at 5. Because when we started, it was like you did not have questions. But now I see you have. Can I check, Honorable Ngola, what is the time that you suggest we must allocate to you?
5 minutes, Chair.
5 minutes?
1, 2, 3, 4, 5.
Okay. So it's only you from the ANC will be asking questions?
Only me, Chair. Thank you.
Okay, thank you. From MKP, I see Honorable Nombalo and Honorable Skosana. 10 minutes. How many, Honorable Skosana? Good afternoon and welcome. Thank you so much for your resilience. I can see you have not been well for the past 2 days and you requested to go and consult. But you You are showing your resilience. Yeah. How many minutes will you want? Honorable Skosan. And Honorable Nomvalo, you said 10. So the two of you combined is 40. Okay. Honorable Mattheys,
30, Chair.
30 minutes, yeah. Bangazita,
15.
15. Okay. Honorable Sols,
30 minutes, Chairperson.
30. No. Look, there is nothing funny about it. Honorable Sols is very loyal to the committee decisions because the committee has said that each and every speaker will be allocated 30 minutes. So he's very loyal, unflinching to our committee decisions.
It says a maximum, Chair, of 30 minutes.
Eh?
It says a maximum of 30 minutes.
He uses the maximum. He plays 90 minutes. Honorable Vessels, nothing. Not even a second. Okay. Honorable James,
5 minutes, please.
5 minutes. Okay. It means today we may be done around 7:30 or 8. So I will use the remainder of the time between the time you finish asking questions and 10 o'clock will be used by the chairperson. So that we stay true to our finishing time of 10 o'clock and 11. So you will be patient with me tonight if I engage the witness for 2 hours. And then, Bonani, may we just make sure that all the witnesses who are coming tomorrow, we confirm with the members today by close of business that we have been able to get all of them. Yeah. Thanks very much, Mr. Chetty. Thank you so much, Advocate Arense. Honorable members, we are now going to break. At 2 o'clock, we are expected to be at the dome. Is the dome? Yeah. For the business of the National Assembly. And once we are done, we will gather at the Good Hope Chambers for members to start engagements with the witness. Thank you so much. May we please stand up and leave the chamber.